Good afternoon, everyone. Thanks for joining us today. My name's Anthony. I head up marketing here at DRS. It's great to see you all for this IBOR discussion this afternoon. Just a very brief piece of housekeeping here. So I'm going to shortly hand over to my colleague Nick, who's going to run through our presentation. Shouldn't take that long. And then we'll hand over to our panel discussion for a chat about the protocol and its implications. If you've got any questions, absolutely welcome. They're on GoToWebinar. There are a couple of options to ask questions. There is a question function on your GoToWebinar control panel, and there is also the chat function. I'll be keeping an eye on both throughout the session. So if you'd like to ask a question or suggest a topic for our panel to debate, please feel free to post it in either of those places. And again, if you have any issues or concerns, just post it in chat and I'll try and get to you as quick as I can. Okay then, without further ado, thank you very much. I'm going to pass over to Nick now to begin the presentation. Thank you.
There we go. Thank you, Anthony. My own welcome to you all. Time's quite short and the protocol covers some 52 pages. And I want to leave as much time as possible for questions. So we're going to look very briefly at how we got here, then a high level overview of the supplement and the protocol. So how do we get here? The problem with LIBOR is that it was never fit for purpose, or only for a very short time. It was set up in the mid-70s to cater for a small number of Eurodollar lenders. In the mid-80s, purely for convenience, the rate was adopted by the early pioneers of the interest rate swap. As we all know, aided by cheap computing, the swaps market proved to be extremely popular. Before long, and almost by accident, the by then various LIBORs had become the reference rates for the world's largest financial markets. Because of its design as a rate for a small club, LIBOR's manipulability was essentially structural. Its subsequent extension into the all-conquering derivatives markets meant that the rewards for manipulation were potentially substantial. Manipulation inevitably followed. Post-2008, and following billions of dollars in fines and the imprisonment of a few traders, it was clear that LIBOR's days were numbered. So the solution. After some initial attempts at structural reform and the appointment of new administrators, regulators finally saw the light and agreed that despite the difficulties in replacing it, LIBOR was essentially unfixable. This gave them two tasks. Firstly, find a replacement rate. Secondly, change all the LIBOR referencing contracts to the new rate. LIBOR was easy to manipulate because it was a poll of a very small number of traders, 15 or so open to collusion. And they were all making subjective credit judgments. This is obviously before the science of XVA desks. So the new rate had to be observable, which meant it was verifiable, and it had to be objective. In choosing the new rate, the consensus focused on overnight lending, still a large and liquid market, and crucially with a minimal credit element. The means for the replacement, at least for derivatives, is the subject of this webinar. The supplement and the protocol. So how does LIBOR actually end? There's no regulation that has a LIBOR deadline. While the EU benchmark regulation will force the FCA to find the rate non-representative, the onus is on national regulators. They've all been very clear that they expect firms to transition to new rates during 2021 for both new and legacy transactions. There's a small selection of quotes on the right-hand side of your screen. This could easily have been pages and pages. There's been some vague talk that there may be a legislative solution for tough legacy contracts, but the insistent and consistent message is that firms must move to new rates by the end of 2021. Likewise, while some internal milestones have shifted due to coronavirus, the end date remains unchanged. There's really no deadline that can be delayed. So this is the problem. Imagine I'm a senior figure in a financial firm. I have a large derivatives portfolio, the vast majority of which reference a rate that will soon no longer exist. Bilateral amendment will be time-consuming and expensive. This is the solution. Nearly all my portfolio references an ISDA definitions booklet, 2006 or earlier. This booklet contains a fallback which kicks in when a rate is temporarily unavailable. So ISDA changed the booklet, updating the fallback so new replacement rates are activated. This is the supplement. I then use a multilateral amendment mechanism, protocol, to amend my legacy transactions so that they reference the new definitions. The death knell is sounded for Libor, my new fallbacks are activated, and my contracts are amended to the new rates. The point is that in combination, the supplement and the protocol are essentially a backdoor mechanism to amend large IBOR referencing legacy portfolios. Of course, in reality, things are not quite so simple or uniformly effective. Regulators are strongly advocating for the protocol while paying lip service to its being limited to only amending fallbacks. At least in public, they're still emphasizing the need for wholesale bilateral amendment. In reality, at least for protocol adherence, the certainty that fallbacks will apply means that bilateral amendment can be avoided, at least in part. So at a high level, how do the supplement and the protocol work in practice? Firstly, the supplement and the protocol are separate but complementary. Each will first apply as of the effective date. This is the 25th of January 2021. The supplement amends the floating rate definitions by including adjusted risk-free rates as fallback rates. These fallbacks are triggered by defined events. On its own, the supplement only applies to new transactions. These are transactions executed on or after the effective date. The protocol acts as a delivery mechanism to amend large legacy transactions. It does this by incorporating the supplement. Contractual amendment via the protocol will apply as of the effective date or later adherence. So the effective date, 25th of January next year, is a big bang date from which all new derivatives that reference the amended definitions will include new fallback rates, and all legacy transactions between protocol adhering parties will include the new fallback rates. So this is how the supplement excuse me, and the protocol work together and apart in the case of the supplement. But how do they actually work? On paper, the supplement is simple. The definitions currently provide for the temporary non-publication of a rate by obliging the calculation agent to obtain quotes from reference events. This is clearly a fallback mechanism which has zero chance of working if non-publication is anything but temporary. The supplement defines a number of covered definitions booklets. For convenience, I'll only refer to the 2006 definitions. Each of these delineates multiple floating rate options and a fallback mechanism. The supplement replaces each of these rates with specified risk-free rates and instantiates a more robust set of fallbacks. So let's look at the rates in slightly more detail. Here's a table illustrating the IBORs that the supplement will replace: sterling Libor, US dollar Libor, and others, as well as the various rate options which the ISDA definitions booklet currently defines for each currency. So from the left, British Bankers Association sterling Libor, BBA, US dollar Libor, etc. Don't worry about this cough, it's not a new coronavirus one. The final line in the table shows their supplement replacement, the new adjusted risk-free rates. Libor rates are marked in red. As London interbank offered rates, these are subject to the FCA and therefore possibly subject to the pre-cessation trigger. The purpose of the supplement is to replace the thoroughly discredited Libor and IBOR rates. Firstly, with new adjusted risk-free rates, and secondly, with scalable fallback mechanisms. So how does it do it? As we know, the supplement is designed to deal with the permanent cessation of a rate rather than its temporary unavailability for whatever reason. In order to define the true end of a rate, the supplement introduces a new concept, the index cessation event. This will take place when a rate administrator announces that it will no longer publish a rate and that no one else will either. The same announcement can also be made by the administrator's regulator. For LIBORs, subject to the FCA, there's another option. Following market consultations and consequent delay by ISDA, the consensus decided that a pre-cessation trigger should be included. So the FCA makes a public statement that it has judged the rate to be non-representative and that this statement is intended to trigger an index cessation event. Index cessation has to have a date. So the supplement also introduces the concept of index cessation effective date. This is the first date an IBOR is no longer provided, or in the case for LIBOR, is judged to be non-representative by the FCA. Note that the effective date may or may not be the same date as the index cessation event itself. As we'll see later, the protocol includes bilateral templates, which amongst other things may be used to disapply the pre-cessation trigger. So these announcements are the triggers for rate replacement. What exactly are the replacement rates? The fallback rates in the supplement are all-in rates. There are 3 steps to transform a risk-free rate to an all-in rate. Here's the recipe. Firstly, take a risk-free rate, SONIA for instance, and compound it in arrears over the relevant IBOR tenor it's replacing, 3 months, 6 months, etc. Secondly, add an adjustment spread to account for the difference between the virtually no credit component risk-free rate and the credit containing LIBOR. Spread adjustments are based on a 5-year median difference between the 2 rates and are published daily on an indicative basis by Bloomberg. Finally, compounding in arrears means that the rate will not be known until the final day of the period, so the calculation period is shifted back by 2 days. This slide shows the example of SOFR, the US secured overnight financing rate. It's an overnight rate for cash collateralized by US Treasuries and exhibits the characteristics I just went through. As a secured rate, the spread adjustment, the SOFR will likely be higher than the unsecured LIBOR it substitutes for. So we've quickly looked at when the supplement applies, which is when authorities say so, what it applies, and all-in fallback. The next question is, how does it apply? Take a deep breath of this. The supplement date on which the rate ceases to be published or becomes non-representative is defined in the supplement as the index cessation effective date. Fallback rates only apply after the index cessation effective date has occurred. Between the index cessation event and its related effective date, the original IBOR continues to be referenced. Following an index cessation effective date, the rate for the next reset is determined using the applicable all-in fallback rate. Remember that all risk-free rates are backward-looking, so the fallback rate for that reset date will not be known until later in the calculation period on the fallback observation day. In order to effect timely payment, the calculation period for the adjusted risk-free rate is shifted back by 2 days. So, in order to obtain a rate for a particular reset date, the calculation agent will need to access the relevant screen page on the fallback observation day, but the rate obtained should be the rate published in respect of the original fixing date, the rate on which the rate would have been obtained under the original contract terms. This will either be the reset date or 2 London banking days prior. This date's identified on the Bloomberg screen pages as the original IBOR rate record day. So this might be quite a lot to take in over a few minutes. This is a quick recap. An index cessation event occurs, triggering the fallback process and fixing the spread adjustment. The index cessation effective date is identified by the announcers of the cessation event. The in-arrears fallback rate isn't available at the reset date, but is on the fallback observation day. Then payments duly made on the payment date. So we've looked at the basic supplement mechanism: when, what, and how. But what happens when it breaks down? The old fallbacks were never going to work in the event of permanent cessation. But what happens if the new fallbacks are unavailable? The settlement sets out an unavailability waterfall. The given LIBOR tenor is temporarily or permanently unavailable. If publication is just interrupted, normal interpolation rules apply. If a rate is ceased, either pre-ceased by the FCA or deceased by a regulator or administrator, as we've seen, the supplement is triggered and the adjusted risk-free rate applies. Let's take the example of sterling LIBOR and its risk-free rate SONIA. If the new fallback rate, adjusted SONIA, is discontinued for whatever reason, we then fall back to the underlying risk-free rate, unadjusted SONIA, with term and spread adjustments manually applied. In the unlikely case that the underlying rate itself is discontinued, making calculation of an adjusted rate impossible, the national regulator will recommend a rate, which will then be adjusted manually. In the extremely unlikely event that no rate is recommended, or the recommended rate is subsequently discontinued, the final fallback is to a specified national bank rate, in this case the UK bank rate, plus spread, plus adjustment. There's no further fallbacks, but at that point we'd probably all have other things to worry about. So where can we find the rates? So a quick glass of water. Bloomberg won the race to calculate and publish the new adjusted risk-free rates, and they've been doing so daily since July, publishing for each LIBOR tenor the term adjusted rate, the indicative spread adjustment, and the all-in fallback rate, which is the adjusted rate plus the spread. Again, an index cessation effective date occurs. Then, on the fallback observation day, counterparties access the relevant Bloomberg screen to observe the all-in fallback rate for the original fixing date. So for a simple process, the whole thing is quite jargon loaded, and Bloomberg jargon isn't always the same as ISDA's. Helps at hand, or at least on the screen, in Bloomberg's rulebook, which has detailed information concerning rate calculation and its publication process. So in a very small nutshell, that's the supplement. We'll now look at the protocol. We're all familiar with protocols. There's been quite a few. The fallback protocol is typical in being a one-to-many amendment mechanism. It's slightly atypical in only applying to legacy transactions. It defines legacy transactions as those that take place prior to the effective date or the date of mutual adherence thereafter. So if you adhere prior to the official effective date and I adhere after that date, our mutual and actual effective date is the date of ISDA's acceptance of my adherence letter. The protocol officially opened for adherence on the 23rd of October. There's a 3-month adherence period, giving it an effective date of the 25th of January 2021. The last really big protocol, variation margin, was largely a failure with very low take-up. The fallback protocols already had a great start, with 257 entities joining during the escrow period soft launch. As of today, 366 entities have adhered. So unlike the VM attempt, it's a simple protocol without confusing but consequential options. However, like VM, the need for a protocol is immense. I think its success is virtually guaranteed. What documentation does the protocol cover? The protocol covers a very wide range of documents. Its primary purpose is to introduce supplement fallbacks into existing ISDA master agreements, credit support documents, and confirmations. Crucially, it also covers additional master agreements, credit support agreements, and confirmations. To be a protocol covered document, that document must incorporate an ISDA definitions booklet, 2006 definitions, for instance, and it has to reference a rate option as defined in a definitions booklet, say Sterling BBA Libor. Or it can reference an IBOR howsoever defined, effectively just making reference to something calling itself Libor, HIBOR, TIBOR, etc. Obviously, for confirmations to be protocol covered documents, they have to form part of a covered master agreement or a credit support agreement. So documentations are important to us, and we'll look at this in a bit more detail. Limb 3 of the previous slide, reference an IBOR howsoever defined, is particularly interesting as it engages a wide range of non-ISDA documents, notably all versions of the GIMRA, the 2000 and 2010 versions of the GIMSLA, as well as the newish 2018 GIMSA pledge version. It also covers agreements not covered by English or New York law, such as the various French FBF master agreements and the Spanish law CMOFs. It's important to note that while ISDA is satisfied as to the protocol's efficacy to amend these non-ISDA documents, they've not been subject to full due diligence and won't be covered in future ISDA opinions. Also note, the German law DRV is not in scope, and obviously cleared products are not protocol covered documents. The full list is included in the protocol as an additional document annex. I've included it here just to show you how long it is, and copy paste is always an easy slide win. There it is. So that's the in-scope documentation. What are the products? Obviously, the protocol is capable of amending all protocol covered documents. While the list we just saw is extensive, it's largely confined to various forms of master agreement. Perhaps luckily for lawyers, there are very large parts of the financial world which have resisted standardization. The protocol does not cover products such as loans or bonds. The amendment process for these classes becomes much more complex when we look at syndicated loans and the different consent solicitation thresholds for bond amendments in various jurisdictions. It's a subject for a different one. In practice, the protocol is mainly useful to amend only the simplest of OTC derivatives. The protocol only considers covered document transactions. So for packaged or a structured transaction, such as an asset swap, where the swap has to exactly match the underlying floating rate note in respect of triggers or fallbacks, the protocol cannot guarantee a matching amendment to the underlying. For non-linear derivatives, such as range accruals, constant maturity swaps, swaptions, caps, floors, combinations thereof, collars, strangles, the relatively simple fallback options provided by the supplement are unlikely to be sufficient. This is even more clearly the case, though less applicable generally, to more exotic products such as commodity swaps, weather swaps, mortality swaps, inflation swaps. These aren't rates that are defined in any definitions booklet. So even if the protocol only covers a subset of OTC derivatives, although a large one, ISDA's still got you covered. Along with the supplement and the protocol, ISDA have published a template toolkit for non-adhering parties to incorporate the protocol and apply modifications, or for adhering parties to amend its scope and or its effect prior to or following adherence. Specific templates are available to amend the protocol's scope to include agreements or transactions as protocol covered documents, to exclude agreements or transactions as covered documents, to amend excluded agreements so that bespoke provisions apply, as in our earlier asset swap example, And finally, a specific template clause to disapply the FCA LIBOR pre-cessation trigger. All protocols, maybe with the exception of the complex VM protocol, are a one-size-fits-all deal. Legacy portfolios are full of bespoke terms. If you want to preserve your particular dispute resolution process in respect of determinations made by the calculation agent, you will need to amend bilaterally. But ISDA have gone a fair way in providing templates for obvious issues, such as pre-cessation disapplication. So that's the Cliff Notes version of the protocol. If you haven't already adhered or still want to, this is how you do it. It's basically the same as usual. As befits its subject, the protocol is open to all, ISDA members and non-members alike. Adherence is by the usual upload of a PDF signed adherence letter to the site. It is then accepted by ISDA. If that acceptance date falls after the official effective date, the acceptance date becomes the effective date. It's perhaps unusually cheap. ISDA primary members pay a fee with a bulk discount. All others can adhere for free, but before the effective date. Fees will apply after that. I'm not sure what the actual fee is, but I suspect it will be the usual $500 per entity. The protocol allows an agent to adhere on behalf of its clients, even where it has not entered into the relevant agreement as agent on that client's behalf. An agent that does so also agrees to provide the counterparty with evidence of its authority to amend within 15 days of request. This is an effort to resolve agency authority issues that have cropped up in previous protocols. Fund managers have the option to adhere to the protocol on behalf of all principals or to adhere on behalf of only some. If adhering on behalf of a subset, the agent can choose to include or exclude certain principals. And the supplement has prescribed procedures for principal carve-in and carve-out. The protocol also includes representations and warranties, similar to the basic representations clause 3 of the 2002 ISDA. This includes a representation that the execution, delivery, and performance under the protocol do not violate or conflict with any contractual restriction binding on or affecting an adhering party or any of its assets. The lesson is, check your third-party consent before adhering. Although, note that if the third party is itself an adherent, its consents will be deemed as given in respect of amendments made by the protocol. So to conclude, in combination, the supplement and the protocol are an elegant, if slightly circuitous solution to a large and urgent problem. However, it's not really a silver bullet. Protocols always leave a large element of bilateral negotiation. Uptake has been encouraging to date, but historically, protocols have struggled to exceed 50% adherence. Although it's a long list, the protocol only applies to certain master agreements. Within those, it's only suitable for simpler products and standalone transactions. So market participants have to analyse their portfolio, assessing the effects and the appropriateness of the supplement for new transactions, and the effects and the appropriateness of its incorporation via the protocol for legacy transactions. Perhaps over and above its content, the simple fact of the supplement and protocol's long-awaited publication marks the end of the phony war. Market participants can finally pull the trigger on LIBOR amendment projects. So this concludes this introduction to the protocol and the supplement. Thank you all for persevering. I'll now hand over to the real experts, Jonathan, and our distinguished guests for the question and answer session.
Thank you, Nick. And first and foremost, I'm very grateful to our two guests today, who I'll briefly introduce, although many of you may know them already. First, Lucinda Clayton. Lucinda is the head of the Derivatives Advisory Group in the legal team at NatWest Markets, and Ed Parker. Ed, who is a partner at Mayer Brown and is the global head of their derivatives and structures products groups. So they are, for different reasons, both becoming increasingly immersed in the long weeds. So hopefully they'll be able to bring some interesting perspective to the challenge. From your perspective, how confident are you that this protocol will deliver a significant advantage in your efforts to resolve this challenge? And
Jonathan, I think we've lost you there with the internet connection. I'll just check if Lucinda, you can hear me on your side.
Yes,
and
yes, I can hear. Yes.
I can hear you fine, Ed.
Oh, well, I could take that legal, a law firm perspective. What's our view across the market? I think that the protocol is a fantastic step when you look at, for any institution, of the sheer number of derivative transactions that they will have on their books. So one of the first things we've done when we've been acting for clients is, the first question is, well, tell us about your overall derivatives portfolio. And we'll be told, well, we have this huge volume of transactions of uncleared trades. It's with all of the other market-making banks in the streets. That makes up the majority of what we have, the standardized transactions. And we say, well, the protocol's perfect for that. Through market industry initiatives, you've got cleared derivatives that are also well catered for. But where it's where there's more of an issue is, not numerically speaking, not the largest number of derivatives. It's the derivatives which do not fit squarely within that protocol. And that's either because of the type of derivatives that they are, or it's the type of entity that the derivatives are entered into with. So let's take an institution that's got a very strong private wealth component. Well, is the protocol going to be suitable for derivatives transactions entered into with private wealth counterparties who may not understand the protocol, who will be a lot of education would be necessary to do so? And the most suitable way of approaching that could be to say, well, please enter into a private wealth counterparty, please enter into a bilateral agreement. It incorporates the protocol either in short form or long form, probably a long form version. This is what it does, and here's the changes we are making to a very limited portfolio. Another area that can be tricky is wherever a derivative is linked to another instrument. So let's take a real estate finance transaction. It has a hedging aligned to it. Well, an institution is going to want to make sure that the changes to the hedged derivatives occur at the same time as the changes to the loan. And the loan market is not as organized as the derivatives market. There's going to need to be consent to changes in the hedging documentation. Is going to need to be approved as part of any bilateral or syndicated lending arrangement. The timing is going to have to take place, changes are going to have to take place at the same time. And there may be an argument, certainly in Europe, should the changes to the derivative, should that follow the loan, or should changes to the loans IBOR rate follow the derivative? More complicated still would be a portfolio of CDOs that an institution might have. In this case, you're going to have to get bondholders involved to agree to the changes to the IBOR made, and the changes that are made to the interest rate in the note are going to have to run parallel with the loan. At a more sort of nuanced end, an institution may find certain of its counterparties have no appetite to make a change. So the consideration needs to happen. What happens if a counterparty refuses to enter into the protocol? how do you work through the fallbacks and the existing 2006 definitions? And as Nick said, that would eventually lead to the counterparty having to the calculation agent having to make its own calculation of the Libor rate through a dealer poll. There'll be other entities further still that don't wish to enter into the protocol. And we saw a lot of that in previous versions. The VM protocol did not have a wide take-up. To be fair, many of the other ISDA protocols have had very wide and successful uptakes, be it the 2014 ISDA credit derivative definitions protocol. You'll then have a further issue will be, it's one thing to sign up to the protocol. An institution may not want all of its documents to be captured by that protocol. So Nick showed this huge list of other non-ISDA master agreement ISDA documentation swept into the protocol. Well, it may be that an entity, and probably likely, does not want its JMRAs, its JMSLAs, its other securities lending repo documentation to be amended by the protocol. And that will partly be because there will be other rates within the universe of the securities lending arrangement, be it securities lending authorization agreements or otherwise, which also require to be amended. So even when an institution has entered into the protocol, and so has its counterparty, it may still be necessary to enter into an amendment agreement to say, well, actually, we don't want these documents covered by the protocol. We want to deal with those separately. So in my very long-winded answer there, I think the protocol is wonderful. It captures numerically a massive amount of documentation for an institution, but there's a sizable amount which still needs to be identified and then bilaterally mediated. And within that can be a real nugget of difficult things to get through and to mediate, particularly where a number of entities need to make a decision, be it bondholders or lenders, and a derivative needs to be aligned with another product. And that's a lot of work that can't be underestimated, that needs to carry on from now right the way probably through up until pre-cessation event or the end of next year. Lucinda, over to you for your thoughts.
Yeah, no, well, I completely agree. It makes a big change. I think, as Nick says, it's the first time we can now say, yes, we have moved forward, and the sort of starting gun's been shot, and we've actually now got a remediation for quite a large exposure, and that's been very good. I wholeheartedly take your point, though, that there are a number of transactions for which this isn't perfect, and there will be holdouts for that, because obviously any linked product and people won't want to sign up, and probably from a bank perspective and a conduct perspective, we should be looking very carefully at anything that is linked to an underlying product, because fallbacks moving in different directions at different times isn't a good outcome when somebody has been sold a loan and a perfectly hedging swap. So there's that pool, and then the non-linear is the sort of big issue on our agenda at the moment, and how to deal with that. We think it shouldn't at this moment hold people up from signing up, because there's a lot of industry discussion that needs to be done. And given that the vast amount of remediation that can be done through the sign up to the protocol, let's get that sort of done and dusted, and then start to consider the non-linear and how to work that. And there is, I know, a lot of market work being done on that, and where that goes, I think, is just a sort of wait to see at the moment.
Listen, I might just add to that it's not whether the protocol is ideal or not is not necessarily a binary decision.
No.
A lot of things will be swept into the protocol, wonderful, all those standard interest rate swaps, but where something isn't suitable, the natural arrangement is still one of these is the templates that for the bilateral short form or long form agreement that Nick discussed, which incorporates the protocol by reference or in long form at the back, and then the amendments are made on the basis of that. So it's still an incredibly useful tool, even where it's not perfect for these products.
I agree, and I also think to that, whilst it's not perfect, it's certainly much better than falling back to the dealer poll, which we know doesn't give any result at all. So I think it's whatever product you have, even if it ends up in a situation, I think there are products where it's commercially not great, so caps and floors and things where it doesn't perhaps achieve a commercial result that you want. And there are things with the arrears swaps and things where it doesn't really even work, but it still gives you an answer, which previously, if you don't sign up, you've got no answer, you've got dealer poll and no ability to get any quotes really.
And I don't think there's really an alternative, is there, that you've got to use it as a base and amend from there. I haven't see anybody doing anything entirely bespoke, saying, well, let's put the protocol to one side, let's come up with our own solution. Well, nobody, who's got the time for one? But
and also, I think that's why there's this sort of delay on the non-linear side, is that it's very difficult to have a bespoke solution that the whole market's going to agree with. So you know, hence the just get the majority of a product signed and then try and work out going forward, you know, what to do with those more bespoke things by having bilateral conversations.
I think there were some attempts made in the VM protocol for bespoke solutions, and they weren't wonderfully successful. Although actually some of them were very good ideas. It's just they couldn't get traction in that short time.
Yeah, I think add to the complexity, you rule out the people who are going to sign up.
Thank you both for that. And I'm hoping I'm back now. Apologies, I had to run out and put some more money in the meter, clearly, for my shaky rural broadband. So apologies if I missed that there. I mean, one of the things I think that I guess it's more a sort of a commercial issue than potentially a legal issue is there's obviously concern about the liquidity in some of these new risk-free rates that, again, now going to be imposed as fallbacks are introduced into transactions. So, for example, something like Sonia already has a reasonable amount of liquidity, something like Sofra not so much. So is there still, are there concerns out in the market? And it's maybe more a question, for both of you, maybe I'll come to Ed first. So will these risk-free rates have enough liquidity and traction to be viable replacements for IBORs? And is that something that's still causing some concern in the industry?
Well, I think you've got it from that. You have that liquidity question swings both ways, because at what, and this of course is why we have the pre-cessation event. So at what time, at what point do the IBOR rates cease to become sufficiently liquid for the transaction? So we get the regulatory announcement, we get the pre-cessation events, but at the same time, when do the new rates become significantly liquid to switch over to these? So certainly when we've had those questions come through, it's very much, you know, it's a crystal ball question that we can't answer. We can't say, we can say, well, it's probably not going to be in the very early part of the year that you get that movement across, and the closer you get to the end of the year, the less likely it is. Are you likely to see it over the summer is another question. But there will be a movement at some point where LIBOR is no longer liquid and the new rate most likely is. But sitting in my ivory tower, with legal tomes piled up, I don't get the visibility that Lucinda would on that question.
So I'd say we're in that state of flux at the moment, and we are sort of trying to keep an eye on all trades that are being done at the moment, and trying to start to hold front office a bit more to account in terms of when they're using LIBOR products instead of the RFR. But for many reasons, LIBOR is still appropriate. One is that the market isn't developed enough. There have been other reasons around systems upgrade and things like that. But hopefully, as time moves on, we'll start to chip away at all of those, and gradually, you know, before the end of next year, all of those would have gone, and all trading going forward will be on the RFR.
Yep, and I think, apologies, it may be something that you covered when I dropped off, but I think one of the things that Nick, you mentioned in passing in your presentation was this issue of tough legacy contracts, which I think is another sort of looming bear trap out there. So are there any prospects for a broader, even perhaps a more legislative solution for that issue?
Certainly there's proposals in New York for a legislative solution to deal with those tough legacy contracts and legislate to get a changeover. I've speaking to colleagues, I've found that there's some general skepticism about whether that could be brought through. is there the appetite at legislative level to do that or not? But I think my answer would be, don't count on it. Prepare for everything that's assuming it won't happen, and if there's a lovely surprise and there's a legislation solution can come through, that's great. I suspect numerically it's not going to be that big a problem when you look at the size of the market. There may be a number of transactions where it's needed, but again, just being that little bit further away from speaking to those clients, it's harder to see. Without it, of course, there will be litigation around this. As mentioned in Nick's presentation, the existing fallbacks are completely lacking. The calculation agent going to do these polls, but is it even feasible to do the polls where you've got a counterparty who just refuses to engage with the new process?
We also have the sort of the various potential tough legacy solutions. The US, the UK, and the EU are sort of a jigsaw that don't necessarily patch together very well, and with gaps, and potentially, back to Ed's point, litigation if somebody's not happy with the path that's been taken. So I think it's helpful for particularly complex transactions, for the bonds which need 100% consent on the consent solicitation, things like that. But it won't be this panacea that will solve everything.
Good, thanks for that. I guess a practical consideration, and one that you're probably in the teeth of at the moment, Lucinda, is that for a variety of reasons, partly I guess maybe a lack of regulatory coordination, or maybe it is just in some form of intelligent design, but also complicated slightly by COVID. 2021 is a year where a lot of things are going to land at once. We've got Libor transition, we've got the postponement of phase 5 of IM leaching into phase 6 of IM. We've got the joys of things like CSDR coming down the pipes as well. I mean, practically, this must be. I mean, we seem to be in this constant cycle of regulatory update for the past sort of 5 or 6 years or so. But this is, I think, is going to be one of the more extreme years, I would have thought.
Yeah. Yes, it is, and also constantly going out to clients with endless updates, and Brexit in the mix as well, asking them to review things, sign up. We're very concerned and wary of a kind of client fatigue of another notification coming their way as part of all of these regulatory changes. But internally, yes, it takes a lot of resource. The new the fallback, the RFR SONIA fallback is different from the SONIA floating rate options, so there'll have to be tech builds for that as well. It has quite a lot of impact right across the whole of the bank when trying to implement it, keeping track of clients that may be turned green for certain reasons. They've done their IM, but actually we haven't managed to get them to sign up to the ISDA protocol, so the fallback protocol. So should we turn them red again? All of these moving parts together will need to be managed, and as you say, more than we've ever probably had to do before.
And of course, there's no, well, the regulators have said there is not going to be a delay in this process, although their track record of agreeing to last-minute delays is quite a regular thing, and we saw that recently with phase 5 of initial margin, right up until very late in the process. There would be no delay in this deadline, and then suddenly you get things pushed out a year. And indeed, the legislation to do that never even caught up with it at EU level. And there was a terrible fudge in the summer with there'd been a recommendation from ESMA, the regulator, in its proposed draft that there'd be a delay in phase 5 initial margin. Nothing was really done to change that at legislative level. So we can always see these delays, but I don't see any feeling in the market that we shouldn't be doing anything other than full speed ahead, get this all done, get this done for the end end of next year. So at the moment, it seems like, yes, everything really is going to happen at the timetable that's suggested, although it would not surprise me if there's some sort of delay comes somewhere down the line. They have form, after all.
Just another quick question coming from the audience, picking up on something that you both touched upon in one of your previous answers, is in relation to non-linear derivatives. Is there any expectation, or I guess indeed hope, to have industry-based solutions for that particular problem? So, for instance, is there any prospect of there being developed templates with specific changes to address particular types of documentation or products?
So I think there is hope that there'll be an industry solution, and the industry is working on it. Our experience with swaptions hasn't made us particularly confident, but yes, there is, I think, quite a strong hope that they'll be sorted out. I'm not sure that there will be templates with those solutions baked in. I think ISDA have felt that that's too difficult, and bilateral transactions, particularly the more complex ones, by definition the non-linear ones, are going to be more difficult to prepare for. But hopefully, yes, there will start to be industry solutions.
And as it stands, you've got the basics for doing it with the bilateral amendment agreements. You've got also some very helpful option language that's been released by ISDA for excluding certain agreements, including others. But it is at quite a basic level. It doesn't go to that extra piece, was here's your particular non-linear agreement.
Fallback.
How you should do it. It's very much you're on your own on that one. Talk to each other and put that. We've given you the basic template to do it. We've given you the protocol you can reference, but it's up to you as counterparties to make that work.
And I think it is probably right. I think ISDA have mentioned that for some of these transactions, fallbacks aren't appropriate actually, and we should be making an effort to transition. Bearing in mind that fallbacks are always not the ideal. Transition is the ideal for every single product. Obviously now with the sort of vanilla stuff, it does work, but for anything more complex, I think we should be trying to transition as much as possible before the end of next year.
And we're coming close to the end of the hour. So I just thought, before we wrap this up, from both of your perspectives, having been embroiled in this challenge for a little while now, if some of the people attending this webinar are more in the foothills of the Libor challenge, what would be your your top tips at this stage in terms of what are the things that have presented, for example, Lucinda, from your experience, the largest challenges in this process? And they may not be legal challenges, they may exist in other areas of your organization.
So data, as usual, as always, we always fall down on data, and getting hold of that, getting hold of agreements has been difficult. And I hope that we're not the only bank that suffers from that. Keeping on top of that, because actually new trades are put on all the time. So that has been something that I think we've had to get up to speed pretty quickly on. And then market developments, again, they move very, very quickly. And so keeping a watching eye out on everything that comes out all the time, because things do develop all the time, has been something else that we think that we really need to keep an eye on.
I mean, I think I'd add, and it's very related to Lucinda's point, is first of all, know what you have as your portfolio of derivatives. Know what the categories are. Once you've isolated what can purely fall into the protocol, make sure you're monitoring to see who else has signed up. And of course, you can be sure that the biggest institutions have signed up. But what about the ones with the transactions with the orphan banks, which may still have a number of transactions outstanding? What about the ones with hedge funds, or making sure that with agents, fund managers, all the things that are a little bit different, being on top of that overall portfolio? Absolutely, problem getting hold of the documents. There has been talk of AI, go set up the artificial intelligence system, go off, make a cup of tea, come back, it's all be done. Now, it's not been our experience of that. So don't think, I would say, that AI can provide anything like the solutions that it can be useful, but can't provide as much help, especially where you've got photocopies of agreements that are in multiple parts and need to be really read through. for their nuances. And the final thing I'd say is make sure you're talking as an institution to other groups. Many institutions will be divided in their own silos. So a CDO group may need to be contacted early by the derivatives group. The loans group needs to be talking with its hedge counterparties. The private wealth team needs to be involved early on as well, and be able to share that information in something which often for good reasons is not normally shared between different areas of the bank. So obviously, Lucinda, that's a much bigger problem for you, and we see that from the outside, but we recognise that many institutions, it's difficult to get parts of the bank to connect that are not always doing so, perhaps for regulatory reasons.
Yeah, and also the industry groups aren't necessarily following each other, so you know that exacerbates the problems internally, as the bond group follows ICMA and the loan group follows the LMA, sort of corralling everybody together so that at least we keep an eye on what everyone else is doing, and so as part of that planning for any transitioning, you know, we can try and do it as easily as possible for everyone.
Great. I agree.
Well, thank you both. It's approaching 4:30 now, so I think that sounds like a good time to wrap up. Thanks very much again to Ed and Lucinda. Really appreciate your insights there, and thank you for taking the time to join us today. Thank you to everyone who attended the webinar. I hope you found it useful and interesting. We'll be looking to circulate a recording of the webinar shortly, so hopefully you will receive that. If there are any topics that we didn't get to cover today, anything that springs to mind after the event, please don't hesitate to contact us. We're always happy to engage in conversations with people around any of these topics. So hopefully we'll hear from you soon. But with that, Anthony, if you could close the call. Thank you very much indeed.
Thanks.
Cheers.
Thank you.